Real quick before we roll this footage. Senator Welch just sat down across from Trump's former personal criminal attorney, who is now the Deputy Attorney General of the United States, and asked him one of the most straightforward conflict of interest questions you're ever going to hear asked in a Senate hearing room. And the answer he got back, or more accurately, the answer he did not get back, is going to tell you everything you need to know about how this administration views the line between Donald Trump's personal legal interests and the interests of the American people. Watch this.
Thank you very much, Mr. Chairman. Thank you very much, Deputy Attorney General. I want to talk to you a little bit about the Anti-Weaponization Fund. Just by way of background, you've had a long-standing relationship, of course, with President Trump, served as his personal criminal attorney, right?
I met him for the first time a couple years ago.
Right. And in the course of your representation of the president, you earned over $9 million, correct?
Well, my law firm was paid that much. I had 6 or 7 lawyers.
Well, that was in your financial disclosures. I don't have a problem.
Oh, no, I did. I was paid it. Sorry, but I'm saying it went to my law firm. I had employees.
Right. It's been raised that you have a close relationship with the president, but you're entitled to that, and the president is entitled to appoint as Attorney General a person in whom he has some trust. So that's not an issue for me. But on the Anti-Weaponization Fund, there is the question of whether a president who is suing the taxpayers, the IRS, for $10 billion, and where his formerly personal lawyer is representing the taxpayers, is there a conflict of interest? And my understanding is that before you actually got here, you did get ethics training when you were, after you were acting Deputy Attorney General, correct?
Yes.
And my understanding is that you were advised that you should not be engaged in matters that affected President Trump in his individual capacity. Is that correct?
No, I'm not sure what your understanding is based upon, but no. There's very clear ethics rules that I was required to follow that I do follow.
It's based on a letter from Mr. Terrell, and you received normal ethics training.
Yes.
And normal ethics includes that you do not represent someone with whom you have been representing them before in a personal matter, right?
I'm not trying to get uber technical, but there are very technical rules around the ethics requirements, and I follow them.
All right. Well, maybe you could provide us with what the ethical materials
I can tell you right now if you're interested.
What I'd like you to do is send us the materials. Let me go on. If you had an issue, there was a dispute about, say, Paramount, would you have a lawyer from the Justice Department who owned $9 million in stock negotiate on behalf of the government with that company?
It depends on as long as there's an ethical and no reason there was no conflict.
So if I had $9 million in stock with Paramount, I'm representing the people. There's an adverse relationship, adversarial relationship. You'd let me negotiate on behalf of the people when the outcome of those negotiations would have an impact on my stock price?
Sorry, I just want to understand your hypo. If a lawyer for the Department of Justice has $9 million in Paramount stock, they should not be on that case.
Right.
I agree. Yes.
Okay. And, you know, what happened here with the president that's so mystifying to many of us, it would be analogous if the governor of Vermont sued the Department of Taxes for $10 billion. And we don't appoint attorney generals, but in New Hampshire they do, but let's say we did. And the governor is formerly personal attorney.
There's no comparison
Let me finish my question. The governor sues the Department of Taxes for $10 billion. His former personal attorney, who's now appointed attorney general, negotiates with the Department of Taxes and ends up settling by setting up a fund in the control, essentially, of the governor for $1.776 billion. That doesn't sound fishy to you?
Well, the hypo you just described, I don't think it's appropriate to use the word fishy. It's either ethical or not ethical,
Well,
and there's
Vermonters would just say it stinks. I mean, that is truly bizarre, that the chief executive gets his appointed person who was formerly his personal attorney to negotiate on his behalf, where at the end of the day, taxpayers are going to pay. So I'll just leave it at
But
that.
the other thing I'll correct, though, is you use the word as if I negotiated. I wasn't part of the negotiation, which I've said before.
Your
so-
department is. You had to sign
Yes,
off on it.
that's true.
That is your signature.
Yes, that is
So
my signature.
look, you're at the top of the pile here. So
Yes.
you don't get involved in all the phone calls and all the details. But at the end of the day, you have to do due diligence and satisfy yourself that you in good faith can sign off on the agreement.
Correct.
And you did. So
Yes.
that is your responsibility, and I'm sure you accept.
Oh, I do have responsibility for it.
That's
I agree
right.
with that. Yes.
All right. And, let's talk about the pardons.
Welcome back to Winner's Breakdowns. I'm Winner, and if that clip did not make you feel something deep in your gut about what is happening to the Department of Justice right now, then I want you to watch it one more time, because there's a level of brazenness on display in that exchange that I think is genuinely historic and genuinely alarming, and every American, regardless of their politics, deserves to understand exactly what they just watched. If you're new here, hit that subscribe button right now. Smash that like button. Drop a comment telling me what you thought the moment that clip ended, because I read every single one, and today I especially want to hear from you. Let's break all of this down completely, because what you just watched was not a complicated legal argument about technical ethics rules and regulatory frameworks. What you just watched was a United States senator laying out one of the clearest and most straightforward conflict of interest scenarios that you can construct in American public life, and a Deputy Attorney General of the United States sitting there and refusing to acknowledge what every single person watching that exchange already knew in their bones. This is not subtle. This is not ambiguous. This is not a situation where reasonable people can look at the same facts and reach genuinely different conclusions about whether there is a problem here. This is a textbook case of exactly the kind of conflict of interest that ethics rules, recusal requirements, and the entire framework of legal professional responsibility were designed to prevent. And it is happening right now at the very top of the Department of Justice. Let's lay out the facts as clearly as they deserve to be laid out, because I think sometimes in these political moments, the sheer audacity of what is happening can actually make it harder to see, not easier, because your brain keeps telling you that it cannot possibly be this obvious. Todd Blanche served as Donald Trump's personal criminal attorney. He represented Trump in some of the most consequential criminal legal proceedings in American history. His law firm was paid over $9 million for that representation. Over $9 million flowing from Donald Trump personally to Todd Blanche's professional pocket. That is not a casual professional relationship. That is one of the most intimate and financially significant attorney-client relationships that exists in the legal profession. And then Donald Trump appointed Todd Blanche as Deputy Attorney General of the United States, one of the 2 or 3 most powerful law enforcement positions in the entire federal government. And simultaneously, Donald Trump is suing the IRS, which means he is suing American taxpayers for $10 billion. $10 billion. And the Department of Justice, which Todd Blanche now helps lead, is the entity responsible for representing the interests of American taxpayers in that dispute. So let me make sure everybody understands what that means in plain English. The man who earned over $9 million representing Donald Trump personally is now in a position of authority over the federal government's response to a $10 billion lawsuit that Donald Trump has filed against the American people. And this arrangement was put in place by Donald Trump himself when he appointed Blanche to that position. Senator Welch's hypothetical about the stock was so perfectly constructed that I want to make sure everybody caught exactly what he was doing with it. He asked Blanche directly, if a DOJ lawyer owned $9 million worth of stock in Paramount, should that lawyer be allowed to negotiate on behalf of the American government in a dispute with Paramount where the outcome of those negotiations would directly affect the value of that lawyer's stock? And Blanche said no. He agreed. He said if a lawyer for the Department of Justice has $9 million in Paramount stock, they should not be on that case. He said it clearly and without hesitation because it is obviously correct, and he had no choice but to agree with it. And then Welch walked him right into the exact parallel he had just set up. Because what is the difference between a lawyer with $9 million in Paramount stock negotiating against Paramount on behalf of the government and a lawyer who earned $9 million representing Donald Trump personally, now overseeing the government's response to a $10 billion lawsuit filed by Donald Trump against the government? The financial entanglement is the same. The conflict of interest is the same. The fundamental problem of asking someone to serve the public interest in a matter directly connected to their most significant prior professional and financial relationship is identical in both cases. Blanche agreed the stock scenario was impermissible, but he refused to acknowledge the parallel that Welch had drawn so precisely because acknowledging it would have meant acknowledging that his own position is ethically untenable. And then Welch constructed the state-level analogy, and I want to spend real time on this one because I think it is the most accessible and the most devastating way to understand what is actually happening here. Imagine the governor of a state sues the State Department of Taxation for $10 billion. And then that same governor appoints his own former personal attorney, the lawyer who just spent years defending him in his most serious legal battles and who earned millions of dollars doing so, as the state attorney general. And that attorney general oversees a negotiation that results in a settlement where $1.776 billion ends up in a fund that is essentially controlled by the governor who filed the lawsuit. Would anyone in this country look at that arrangement and say there is nothing to see here? Would anyone in this country look at that and say this is just normal government functioning as intended? Of course not. It would be a scandal of the first order in any state in the country. The editorial boards would be calling for resignations. The ethics commissions would be opening investigations. The calls for accountability would be deafening. But because this is happening at the federal level, because the names involved are Donald Trump and Todd Blanche rather than some state governor and his local attorney, and because we have become so exhausted by the volume of norm violations and ethical breaches coming out of this administration that it is hard to maintain the appropriate level of outrage for each individual one. This settlement and this conflict of interest have not gotten anywhere near the attention they deserve from the American public. Senator Welch understood that, and that is why he took the time to construct those analogies so carefully. He was trying to cut through the numbing effect of constant ethical chaos and make people feel in their gut what is actually at stake here. And I want to talk about Blanche's response to the word fishy, because I think it actually revealed something quite significant about how this administration relates to questions of ethics and accountability. When Welch asked whether the arrangement he had just described sounded fishy, Blanche said he did not think it was appropriate to use the word fishy, that it should be judged as either ethical or unethical. And look, on one level that is a fair point. Legal ethics is a technical field and informal characterizations can obscure more than they reveal. But on another level, the response of a person with genuinely clean hands and a genuinely defensible ethical position when asked if something sounds fishy is not to quibble about the vocabulary. It is to say no, it does not sound fishy, and here is exactly why. It is to lay out the specific ethical analysis that demonstrates why the conflict of interest concern does not apply in this situation. Blanche did not do that. He quibbled about the word and then retreated to vague assurances about the technical ethics rules he follows. And the exchange about his signature on the agreement was perhaps the most important moment in the entire clip, and I am not sure it got the attention it deserved in real time. Blanche tried to create distance between himself and the settlement by saying he was not personally involved in the negotiations. Welch came right back and pointed out that Blanche's signature is on the final agreement. And Blanche acknowledged it. He said, "Yes, that is my signature." And then Welch made the point that needed to be made, that when you are at the top of the organizational hierarchy, you do not have to be in every phone call and every detail session to bear responsibility for the outcome. The Deputy Attorney General signing off on an agreement is not a ministerial act. It is an exercise of authority and judgment and accountability. You cannot earn the title and the power and the authority that comes with being Deputy Attorney General of the United States and then disclaim responsibility for the agreements that bear your signature by saying you were not in the room for the negotiations. Blanche actually acknowledged this. He said, "I do have responsibility for it." I agree with that, which is an extraordinarily significant admission when you think about what it means in the context of everything that surrounds that agreement. He has responsibility for a settlement that channeled $1.776 billion into a fund with an arrangement that raises serious questions about who actually controls it, signed off on by a man who earned over $9 million representing the person who filed the lawsuit that created the need for the settlement in the first place. And he has responsibility for it. His words, not an accusation, his own words. This is what the corruption of the Department of Justice looks like in practice. It does not always look like a dramatic movie villain making explicit corrupt bargains in smoke-filled rooms. Sometimes it looks like this, a carefully worded Senate hearing exchange where a deputy attorney general refuses to acknowledge an obvious conflict of interest, quibbles about the word fishy, admits his signature is on the agreement, acknowledges his responsibility for it, and then moves on as if the plain meaning of everything he just said has not registered in the room. It is the corruption of normalcy. The corruption of bureaucratic procedure. The corruption of making something that should be obviously disqualifying seem like just another debatable policy question. Senator Welch refused to let it be normalized. He pushed, he pressed, he constructed his hypotheticals with precision, he walked Blanche through his own logical concessions step by step, and he made the record. And making the record matters enormously even when the immediate result of making the record is a witness who refuses to give you the admission you are seeking. Because the American people deserve to see these questions asked clearly and persistently and professionally. They deserve to see their elected representatives doing the work of holding extraordinary power to account even when that power is doing everything it can to avoid accountability. And they deserve to have the dots connected for them in plain language so they can understand what is actually at stake in these hearings beyond the political theater and the procedural back and forth. What is at stake is simple. The Department of Justice belongs to the American people. It does not belong to Donald Trump. It is not an instrument of his personal legal strategy. It is not a tool for protecting his financial interests or settling his personal lawsuits on favorable terms. The Attorney General and the Deputy Attorney General are supposed to serve the public interest, the constitutional order, and the rule of law, not the personal and financial interests of the man who appointed them. And when the Deputy Attorney General is someone who earned $9 million representing that man personally before taking the job, the conflict between those two obligations is not theoretical. It is immediate. It is documented, and it is playing out in real time in settlements and agreements that the American taxpayer is going to be paying for. Democrats on this committee need to keep doing exactly what Welch did in that room. Keep showing up with the specific questions. Keep walking witnesses through their own logical concessions. Keep making the record clearly and professionally and persistently. Because the road to accountability runs through the documented record, and every exchange like the one we just watched adds another brick to that road. So drop a comment and tell me what hit you hardest in that clip. Was it the $9 million prior relationship? Was it the $10 billion lawsuit running simultaneously? Was it the $1.776 billion settlement? Was it Blanche's refusal to acknowledge the parallel Welch drew so precisely? Was it the admission that his signature is on the agreement and that he accepts responsibility for it? I want to hear all of it, because this is exactly the kind of conversation Winners Breakdowns was built to have. If you believe that the Department of Justice belongs to the American people and not to the personal legal interests of the president who appointed its leadership, if you believe that conflict of interest rules exist for a reason and that reason does not disappear when the person with the conflict happens to be powerful enough to appoint himself above the rules, then you know exactly what to do right now. Hit that subscribe button, smash that like, and share this video with every American in your life who deserves to understand what is actually happening inside the Department of Justice right now and why it matters for every single one of us. This has been Winners Breakdowns. Stay informed, stay outraged about the right things, stay committed to holding power accountable no matter how high it sits, and I will catch you in the next one.